Hi, so I'm going to discuss now about Rule 110 of the Rules of Court, which talks about the prosecution of offense. So within this topic, we will discuss the institution of criminal action. What's the difference between complaint and information? When complaint or information is sufficient? Who will institute criminal action or who will prosecute? And another is duplicity of offense. We will also discuss about amendment or substitution of complaint or information. Where, and lastly, where or what particular place wherein you can institute a criminal action. To start, we will discuss about the institution of criminal action. So for an offense where a preliminary investigation is required, pursuant to Section 1 of Rule 112, so it will be by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. So second, for all other offenses, by filing the complaint of our information directly with the municipal trial court or municipal circuit trial court, or the complaint with the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. So, the institution of criminal action, so saan ka mag-i-institute, saan mo i-file yung criminal action. So, as to Section A, talks about you will going to file in the proper office, where the preliminary investigation is conducted. Yan. Second is that in MTC or MCTC, for all other offenses not prescribed on Rule 112. So usually kapag more than 3 years, that's regional trial court manggod. Okay, so what is complaint or information? How they differ from each other? So, when we say complaint, it is a sworn statement or a sworn written statement charging a person with an offense. So, in other words, you are filing or you are charging a person a certain offense. Kinasuhan mo siya. Kinasuhan ba? Or you're filing a reklamo. Nagpa-file ka ng reklamo against another person. So, the one who will file that one is either it is subscribed by the offended party or the complainant, any peace officer or other public officer charged with the enforcement of the law violated. So, on the other hand, when we say information, that is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So, kung titingnan natin, ang kaibahan ay kung sino yung nag-subscribe. In the information, the one who subscribed is the prosecutor. Okay? So, who must prosecute criminal action? So, that question, sino ba yung mag-prosecute ng criminal action? All criminal action commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutors. In other words, the one who will prosecute is the prosecutor. However, in the municipal trial court or MCTC, when the prosecutor assigned thereto or to the case is not available, it can be prosecuted by the offended party, the peace officer, or public officer charged with the enforcement of the law violated. So, in other words, those people can also prosecute the case. So, in case if it is within municipal trial court and the prosecutor is not available. So, this authority sees upon actual intervention of the prosecutor or upon elevation of the case to the regional trial court. So, yung pangalawa, hindi yun pwedeng i-prosecute or hindi pwedeng i-prosecute the offended party if the prosecutor is available or if the case elevate in the regional trial court. So, the crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended party. So, in cases of adultery and concubinage, so the one who will file or prosecute must be the complainant or the other party, or it could be the offended spouse o yung husband o kaya yung wife. So in cases of seduction, abduction, and acts of lasciviousness, it shall not be prosecuted except upon complaint filed by the offended party or her parents, guardians, or grandparents. Nor in any case, if the offender has been expressly pardoned by any of them, if the offended party dies or become incapacitated before she can file the complaint, and she has no known parents, grandparents, or guardian, the state shall initiate the criminal action in her behalf. So in other words, in cases of seduction, abductions, acts of lasciviousness, the one who will prosecute the criminal action is the offended party. If none, it could be her parents, her grandparents, or guardian. If ever namatay yung biktima, or kaya nawalan ng pag-iisip, and then walang parents, walang guardian, then it could be the state. The state can file the criminal action. Now, the question is, when a complaint or information sufficient? Kailan ba magiging sufficient yung criminal action, yung complaint or information? So it is stated that the following should be stated, such as the name of the accused, the designation of the offense given by the statute, the acts or omission complained of us constituting the offense, the name of the offended party, the approximate date of the commission of the offense, and the place where the offense was committed. So those things should be stipulated within the complaint or information to make it sufficient. So, magiging sufficient lang yung information o kaya complaint kapag yung mga yan ay nakastate or nakapaloob sa loob ng complaint or kaya information. So, in the name of the accused, it is said that the complaint or information must state the name and surname of the accused or any appellation or nickname by which he has been or known. If his name cannot be known or cannot be ascertained, he must be described under a fictitious name with a statement that his true name is unknown. If the true name of the accused is thereafter disclosed by him or appears in some other manner to the court, such true name shall be inserted in the complaint or information and record. Yan. In the designation of offense, the complaint or information shall state the designation of the offense given by the statute, aware the acts or omission constituting the offense, and specify its qualifying and aggravating circumstances. If there is no designation of the offense, reference shall be made to the section or subsections of the statute punishing it. Okay. Cost of the accusation as being stated, or the acts or omission complained of as constituting the offense, and the qualifying and aggravating circumstances must be stated in the complaint or information, and it must be stated in an ordinary and concise language, and not necessarily in the language used in the statute, but in the terms sufficient to enable a person of common understanding to know what offense is being charged, as well as its qualifying and aggravating circumstances, and for the court to pronounce judgment. So, place of the commission of offense. So, the place of the commission of offense shall be stated in the complaint or information. So, the complaint or information is sufficient if it can be understood from its allegation that the offense has committed or some of the essential ingredients occurs on some place or at some place within the jurisdiction of the court, unless the particular place where it was committed constitute an essential element of the offense or it is necessary for its identification. Okay? So, the date of the commission of offense, it is not necessary to state in the complaint or information the precise date that the offense was committed, except when it is material ingredient of the offense. So, one certain offense that it is in need to determine a specific date or a specific day. So, one of it is the crime of infanticide. So, why we need to indicate the date of the commission of an offense? Because in infanticide cases, it is one of the ingredients of the crime to determine the number of days where the child is born. So, it is said that it must be 3 days. So, 3 araw siyang na panganak before siya pinatay. Okay. So, dapat pinatay siya 3 days before, 3 days after. 3 days after ba, no? The period where the child is being killed, it must be within 3 days after the delivery of the said child or kung kailan siya pinanganak. Yun. So, kailangan i-identify talaga yung date because that's one of the essential elements of the crime. Pero hindi sa lahat ng kaso kasi may mga cases naman na hindi naman necessary na i-state mo talaga yung date of the commission of the offense. Okay? What are those examples of crime wherein date is not really necessary? So, in cases of theft, robbery. So, it's not really necessary for us to identify or indicate the date. But then, still, it is necessary kung alam mo naman talaga yung petsa, bakit hindi natin ilalagay? Pero, the most important thing is that we need to identify the date of commission of the offense, especially if that date is one of the material ingredient of the offense. So the offense may be alleged to have been committed on the date as near as possible to the actual date of its commission. Kaya, so pwede siya example, nakita natin yung patay or yung katawan ng patay is today, but we do not know when is the exact date he was or she was killed. So, pwede natin yung i-assume natin yung possible date when the crime was committed. But it's not necessarily i-indicate talaga natin kung kailan yun kasi hindi naman natin talaga alam yung petsa kung kailan siya pinatay. But then we can have this idea on the alleged date or the presumed date when was the alleged offense committed. Yun. Okay, the name of the offended party. So, the name of the offended party should be indicated. So, the complaint or information must state the name and the surname of the person against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known. If there is no better way of identifying him, he must be described under a fictitious name. So, offended party means the victim side. Okay? So, you need to identify also the name of the offended party or the victim side in the complaint or information. So, now, name of the offended party. In offenses against property, then if the name of the offended party is unknown, the property must be described in such particularity as to the property identify the offense charge. If the true name of the person against whom or against whose property the offense was committed is thereafter disclosed or ascertained, the court must cause the true name to be inserted in the complaint or information in the record. If the offended party is a juridical person, it is sufficient to state its name or any name or designation by which it is known or by which it may be identified. So without need of averring that it is a juridical person or that it is organized in accordance with the law. So yun yung mga rules in writing the name of the offended party. Okay? So duplicity of the offense. So it is said that a complaint or information must charge but one offense. So in a complaint or information, dapat isa lang yung i-charge mo na offense, except when the law prescribe a single punishment for a various offense. So pwede siya unless daw the law prescribe that a single punishment for a various offense. Yan. So, amendment or substitution. So, a complaint or information may be amended in a form or in a substance without leave of court at any time before the accused enters his plea. After the plea and during the trial, formal amendment may only be made with leave of court and when it can be done without causing prejudice to the rights of the accused. However, any amendment before plea which downgrades the nature of the offense charged in or excludes any accused from the complaint or information can be made only upon motion by the prosecutor, with notice to the offended party and with leave of court. The court shall state its reason in resolving the motion and copies of its order shall be furnished all parties, especially the offended party. If it appears that any time before judgment that a mistake has been made in charging the proper offense, the court shall dismiss the original complaint or information upon filing a new one charging the proper offense in accordance with Section 19, Rule 119. How provided the accused shall not be placed in double jeopardy. The court may require the witnesses to give bail for their appearance at the trial. Yan. So, pwede i-amend, pwede i-substitute yung complaint or information provided the requirements given as stated. Yan. So, place where action to be instituted. So, subject to existing laws, the criminal action shall be instituted and tried in a court of the municipality or territory where the offense was committed or where any of its essential ingredients occurred. Where an offense is committed in a train or other public or private vehicle while the course of its trip, the criminal action shall be instituted and tried in the court of any municipality or territory where such train, aircraft, or other vehicle passed during its trip, including the place of its departure and arrival. Where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried in a court of the first port of entry or of any municipality or territory where the vessel passed during such a voyage, subject to the generally accepted principles of international law. Crimes committed outside the Philippines but punishable under Article 2 of the Revised Penal Code shall be cognizable with the court where the criminal action is first filed. Yan. So yun ha. Kung ang criminal action asa siya na-commit, asa na siya nahitabo, asa dito makita na ang mga essential ingredients of the crime, dito siya dapat i-file ang kaso. Kung ang crime na commit, ang offense na commit within the train, any public vehicles wherein it's on its trip. So, you can file the criminal action in any municipality or territory kung saan dumaan yung sasakyan. And it could either, you can also file the criminal action either also on the place of its departure or place of arrival. Similar with on a board or a vessel, pwede ganun din yung mangyayari. Kung saan dumaan, kung saan siya port of entry and any municipal port of entry or kung saan yung vessel dumaan, kung asan yung vessel dumaan, huminto, or nag-start ng voyage. Okay? So, in crimes committed outside the Philippines under Article 2 of the Revised Penal Code, so it will be cognizable by the court where the criminal action is first filed, kung saan unang gi-file yung kaso. So, I think that would be all. Thank you so much for listening. Hope you learned from the discussion. So, if you have further question, you can raise your question now. Thank you.